and I'll let you know when we begin the meeting, Dr. Bechtel.
Okay, thank you.
This conference will now be recorded.
We are now streaming, and you can feel free to begin the meeting. Thank you.
Thank you. The time is now 10:06, and the April 14th, 2021 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel?
Present.
Thank you. Dr. Safran?
Present.
Thank you. Mr. Gacaloni?
Here.
Thank you. Dr. Soin?
Here.
Thank you. Dr. Kanstein?
Here.
Dr. Reddy?
Present.
Dr. Johnson?
Here.
Thank you. Dr. Coccarella?
Present.
Mr. Ganadakis?
Present.
Thank you. Ms. Montgomery?
Yes, present.
Thank you. Dr. Feibel?
Here.
Thank you. And myself, Dr. Bechtel, present. Do I hear a motion to approve the minutes of the March 10th, 2021 board meeting as drafted? Do I have a motion?
So moved.
Dr. Second, Dr. Schottenstein. All in favor, say aye.
Aye.
All opposed? The motion passes. The board will now consider the reports and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matters of Thomas Falls, MD, Gianni Marino, Gianfronte, DO? Roll call. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. Further, does each member of the board understand the board's disciplinary guidelines do not limit any sanctions to be imposed, and the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Gacaloni?
Yes.
Dr. Stein?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of the civil penalties from no fine to the statutory maximum amount of $20,000? Roll call. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Myself, Dr. Bechtel, yes. In accordance with the provision of Ohio Revised Code 4731.22F2, specifying that no member of the board who supervises the investigation of a case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as the secretary and Dr. Safran served as a supervising member. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has been expired. The assistant attorneys general will be subject to the same limitations. We will now turn to the matter of Thomas Falls, MD. Please turn to the matter of Thomas Falls, MD. No objections have been filed. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Falls. 5 minutes will be allowed for the address. You may proceed.
Good morning, everyone. My name is Greg Toposi with the law firm Dismore and Scholl, and we represent Dr. Falls in this matter. We'd like to start out by thanking Ms. Lee for her detailed report and recommendation, to which we have not objected to. In this case, there's no excuse for Dr. Falls' conduct, as he himself has said since his arrest in May of 2018. But it's also important to note that Dr. Falls has by no means ever sought to demean the seriousness of soliciting prostitution and the attendant risk of facilitating human trafficking. But, however, in these types of cases, the board typically knows the physician gets it. In other words, does the physician realize that his or her conduct was wrong, and what has the physician done to make sure that it won't happen again? Here, Dr. Falls gets it. He willingly completed 3 different, mental health evaluations, which involved a multiple day trip to Kansas and another evaluation by a physician approved by this board to opine on a prospective licensee's mental health. All of those evaluations determined that Dr. Falls can practice in accordance with minimum standards of care and without any further restrictions. Dr. Falls has successfully completed probation in his criminal case. He has sought mental health counseling. He also has complied with the terms of his order from the Kentucky Board of Medical Licensure and is eligible for early termination. After seeing Dr. Falls' actions and looking at the case in total, the Kentucky Board reinstated his license without restrictions. The DEA reinstated his registration without restrictions, and insurance payers such as Kentucky Medicaid also reinstated his ability to participate in those panels. You know, the practice of medicine is always going to be stressful, but importantly, Dr. Falls has now developed tools to ensure that his decision making is not compromised in the future. In short, Dr. Falls gets it. So we look at the context of this case in general. We have a young physician in his who had been working for less than a year when all of this happened. Dr. Falls is one of only approximately 20 practitioners across the United States who specialize in limb lengthening and complex reconstruction. He has no other criminal history, much less a speeding ticket. And he has no other disciplinary history for any other state medical board other than related to his 2018 arrest. So, you know, it's unfortunate that Dr. Falls' fellowship here in Ohio fell through, but on the bright side, I think it's fortunate that we have an expert like Dr. Falls who does not want to foreclose the possibility of practicing in Ohio moving forward. So Mrs. recommendation, in our opinion, will protect the citizens of Ohio and also help Dr. Falls continue to grow both as a person as well as a practitioner. So with that, I'll turn the floor over to Dr. Falls for the remainder of our time.
Thank you for giving me the time and the opportunity to address the board today. I would like to begin by saying that I take full responsibility for my actions that led me to this point. I was going through an extremely difficult time, both personally and professionally. However, it does not excuse my actions, and I fully understand that. I've worked my entire career to help people, and so it was never my intention to do anything that could place others in harm's way. I realize now that what I did could have put others in danger and contributed to the scourge that is human trafficking. In my saddened and wounded state of mind at the time, I did not appropriately evaluate my actions. I have undertaken steps to ensure that I never allow anything like this to happen again. I quickly got the mental health treatment that I needed and was able to take time to reflect on my actions and improve myself. I've learned strategies to deal with stress, but also improved my coping skills and taken time to understand that self-care is not only necessary, but must be practiced regularly. I found a wonderful therapist who has helped me work through my issues, and I've refound old hobbies, including regular time at the gym, that helps my general well-being greatly. I'm not the same person that I was 3 years ago, and have even had friends and family members make comments to that effect. I'm stronger, more resilient, and more self-aware than I was before. I'm able to stay calm under stressful conditions and maintain a heightened awareness about my decisions and how they affect others. What happened 3 years ago does not reflect who I am personally or professionally. I had an inexcusable lapse of judgment and made a terrible mistake, but I can only learn from my mistakes going forward and continuously work to ensure that I'm a better person. With my current work for the U.S. Army, I have the opportunity to help individuals, but also serve my country, which gives me a great sense of pride. If granted the opportunity to practice medicine in the state of Ohio, I will not squander that chance, as I know that second chances are hard to come by. Again, I thank you
Dr.
for your time
Falls,
today.
Thank you very much.
Thank you, Dr. Falls. Does the Assistant Attorney General wish to respond?
Good morning. No, at this time I have no response. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Falls? Do I have a motion?
I move the motion.
Do I have a second?
Second.
Dr. Schoenstein, thank you. I'll now entertain discussion concerning the matter of Dr. Falls. Is there any discussion? Ms. Montgomery?
Just a question I'd throw out there. Is there a need to have, in looking at the R&R, it would appear that probation period has to be at least 1 year. I would just ask the board, do we think he needs to be on probation? He's already served one probation for his criminal behavior. Would it be appropriate to make the probation last as long as until he completes the courses that he's required, all of those other, the courses he's required to take, as opposed to making him serve probation? I mean, my suggestion is probation could just last as long as it is required for him to complete the requirements that the R&R suggested.
Thank you, Dr. Feibel.
It's funny you say that, because I was thinking a little bit the opposite, and I agree that I think the majority of the R&R is very good, and I genuinely believe Dr. Falls is remorseful and has taken responsibility for his actions, and I appreciate that, and I look forward to him practicing in Ohio. I would argue that we should mimic the Kentucky order and keep his probation through what the Kentucky order is, unless I'm reading the Kentucky order. Unless I've read the Kentucky order wrong, I think he has about 3 years left on his Kentucky order of probation. And it would seem to me that we would, I know we're not bound by that, but that we would mimic that. They adjudicated this case. And in doing that, I also question a little bit and would love the board's input. And I didn't see it. If I missed it, I apologize. Maybe a boundaries course just to make sure that that he has that tool in his.
Any other discussion? Dr. Schoenstein.
Thank you. So, as to the length of the probation, I think that there's the potential that he gets released early from Kentucky. And so I want to make sure if we're going to mimic Kentucky, the ideal right now is that he uses the time while he's under probation to fulfill his ethics and human trafficking courses. And to Dr. Feibel's point, I certainly think it makes sense to either, specify that there's a boundaries component to the ethics course, or potentially include that. But the other thing is a human trafficking course is probably going to speak to that as well. In other words, he's probably going to get a fair amount of remediation just with these two courses, but it's certainly agreeable to me if there's a board consensus that there should be a boundaries course as well. I think that the idea of the indefinite probation lasting at least a year is reasonable in terms of essentially just giving him the time to get these things done and won't preclude him from practicing. It's also comfortable if we want our probation to end when the courses are done. So I just had a few more thoughts, though, if I may. This is a case of mitigation, of course, and the doctor has acknowledged engaging in the behavior which has been alleged. And I do appreciate that he was under a lot of stress. But what I would also say is that life is full of stress, and it's important as professionals that we manage our stress. So regrettably, when somebody who is prone to clinically significant depression experiences stress, they can have almost like an allergic reaction to that stress. And I think that's what happened in the doctor's case. His reaction to stress was maladaptive and self-destructive. And on some level, it really seems like the doctor knew it. It appears that the doctor attempted to get mental health treatment before his Sentinel event, but had trouble finding help. It sounds though like once the doctor engaged in treatment, he embraced it and made a genuine effort to address his mental health issues. And it sounds like his treatment providers feel that he's made substantial progress. So the initial charge against the doctor of promoting human trafficking was amended down to the soliciting of prostitution. When one solicits a prostitute, there is an accompanying risk of furthering the scourge of human trafficking. So the doctor testified that he has educated himself on the topic of human trafficking and spoken with his therapist about it. The medical board takes human trafficking very seriously. We have created videos that are posted on our YouTube site to bring awareness to this issue. And earlier this year, Governor DeWine initiated an executive order which added the State Medical Board of Ohio to the state's Human Trafficking Task Force. Our investigators have worked closely with the Office of Criminal Justice Services and other law enforcement offices regarding human trafficking issues. So the doctor's decision to solicit an escort for sexual activity, is certainly indefensible, but there are a number of mitigating factors. There's no prior disciplinary record. I believe this is an isolated incident unlikely to recur. He's made full and free disclosure to the board. He's taken the interim remedial measure to engage in counseling. He's expressed what I perceive to be genuine remorse, and he's taken responsibility for his actions. There are aggravating factors as well. He had a selfish motive, and his behavior was reckless. He knew better, but he did it anyway. So my thought was that the proposed order is a proportional response to the allegation, given the balance of aggravating and mitigating circumstances. I think we're right to grant the license. I think the reprimand is appropriate. And so, as I said, I think the ethics and human trafficking courses are appropriate. If anyone is inclined to add a boundaries course, I would support that. And if there's a sense of having the probationary period end when the courses are completed, I think I'm also fine with that. Thank you.
Does anyone wish to make an amendment to the proposed order? To make a motion?
I would move that we amend the proposal to include a boundaries course, and that probation would extend until all of those requirements of probation and all of those courses are taken.
I'll second.
Okay, we have a motion by Ms. Montgomery, a second by Dr. Schottenstein, and I'd like to take a roll call on that proposal. Dr. Rothermel?
Abstain.
Don't you want discussion first?
I'm sorry? Or any more discussion?
I don't know whether anyone else has discussion on it or not.
Go ahead, Dr. Feibel.
I've already said what I feel. I feel that while I agree with everything Michael and Dr. Schottenstein and Ms. Montgomery have said about his mitigating circumstances and that type of thing, I think we as a board need to come down strongly on human trafficking, and the fact that we are part of that task force. I think I don't think it affects him in any way, his ability to practice being on probation for the time that he's on probation in Kentucky. And I think if we add that, I don't know if that's legal for us to add to the order that he's on probation through the period of probationary period in Kentucky. But I think that sends a better message from the board to the public that we feel very strongly that human trafficking is a really big problem, and I wouldn't want to mix that message. So that's all I have to say.
Dr. Schottenstein?
Yeah, I appreciate Dr. Feibel's comments very much. I think the position we potentially find ourselves in is if the doctor is eligible for early release from his probationary term in Kentucky, and he is released from Kentucky before he has had a chance to take these courses that we're recommending, that sort of puts us in a difficult spot because the courses are a condition of his probation. And so if his probation ends and he hasn't fulfilled his courses, I think that makes things a little complicated for us, as opposed to leaving the probation intact until his courses are completed.
I'd like to make a comment as well, and just I very much appreciate all of the discussions here. I'd like to note that a yes vote for this motion does not mean myself personally takes human trafficking lightly. In fact, I feel the exact opposite. At the same time, when you look at having to take all of these courses, already going through probation at another state, and already doing all of these things to another state, at some point, you have to realize what is a proportional response. And I think that I do take human trafficking incredibly seriously. I know this board does, and our fellow board members do. And I just wanted to make that noted.
Thank you.
It also, with all due respect, it also is not only are you worrying about what does it do to the doc and what is our capacity to control, but what we're trying to do is make sure that our probation makes sense. And the staff time taken on cumulatively, the number of people we put on probation that really don't need to be on probation has to be at least an issue. And it doesn't at all diminish, as Dr. Sonia said, the fact that every one of these board members, I am sure, take human trafficking very seriously.
Thank you. I think what we'll do next is, again, vote on the proposed amendment by Ms. Montgomery, and then we'll turn back to Dr. Feibel to see if he wants to make an additional amendment. But vote on the substance of Ms. Montgomery's proposal amendment. We'll then go through a roll call. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Gacaloni?
Yes.
Dr. Sloin?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Kanadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. Then would we move then to vote on Dr. Feibel's amendment also?
Well, Dr. Feibel is free to make a motion to amend. No such motion has been made yet. But if he or any other board member wishes to make an amendment, that can be entertained.
I do not.
Okay. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Falls? Do I have a motion?
So moved, Dr. Johnson.
Second? Thank you. Before voting on the motion to approve and confirm as amended, is there any further discussion? Seeing no further discussion, I will go ahead with a roll call vote. Dr. Rothermel?
Abstain.
Dr. Safran?
Abstain.
Mr. Gacaloni?
Yes.
Dr. Stone?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Thank you. Mr. Ganadakis?
Yes.
I'm a yes, but my screen keeps freezing, so if I freeze, please come back to me. Sorry.
Okay, thank you. And Dr. Bechtel, yes. So the amendment passes. Thank you for your time, Dr. Falls. You may exit the video conference now, and if you wish to view the rest of the public meeting, it is being live streamed on the board's YouTube channel. Thank you. We'll now turn to the matter of John Marino, John Ferrante, DO. Please turn to the matter of Gio Marino, Gian Ferrante, DO. Objections have been filed and were previously distributed to board members. Mr. Porter was the hearing examiner. The request to address the board has been filed on behalf of Dr. John Ferrante. 5 minutes will be allowed for the address. You may go ahead with your address, sir.
Thank you very much, Mr. President, members of the board. Thank you for the opportunity to address you today. I am Douglas Graff, and I'm here on behalf of my client, Dr. Gia Ferrante. He is currently a first-year surgical resident at St. Joseph's Hospital in Toledo. During the application process for his training certificate for the residency program, Dr. Gia Ferrante appropriately notified this board, and as seen in the hearing, he has previously notified his medical school and his residency of an event that occurred at the end of his sophomore year of undergraduate more than 9 years ago. We entered objections, but not to the report and recommendation of Mr. Porter, and we thank him for his thoughtful review of the facts in this matter. But we put in objections to the proposed order. Mr. Porter found that Dr. Gia Ferrante had made an Alfred plea to a misdemeanor assault charge in North Carolina 9 years ago with a female friend. The hearing officer found that Dr. Gia Ferrante had been forthcoming to this board and with others about the event, and that Dr. Gia Ferrante's information did not undermine his proof of good moral character, which he must show to this board. The evidence in the hearing is clear. Dr. Gia Ferrante presented significant additional mitigating evidence of his positive community work, civic-minded activities, his strong family support and commitment. And in the hearing, Dr. Gia Ferrante's medical school advisor, who has known him for more than 5 years, Dr. Connington, and his residency program administrator, Mickey Alfrith, whose name I can't pronounce very well, and his program director, Dr. Heath Dorian, all spoke very highly of Dr. Gia Ferrante's personal character, his work attributes, his work ethic, and his fitness to be a physician. These are all positive values that the board should review in Dr. Gia Ferrante's matter. Our objections have been to the uncertainty of an indefinite suspension. There is a proposal for a 90-day indefinite suspension while Dr. Gia Ferrante is in the residency program. I have heard from his residency program and from the hospital that they would hope that we could give them a definite time so that the program can allow Dr. Gia Ferrante to be within the appropriate rotations and serve them fully whenever the suspension takes effect, and that therefore, if the board finds it appropriate, we would like to have a more definite time frame. As the members of this board know, the timing and precision of rotations is imperative in the residency program, and especially in something like surgery. We also had asked that the board put the requirement of an ethics course into the first year of his license rather than during the period of suspension due to the uncertainty of scheduling of the ethics classes to complete the requirement for the board. I thank you for the opportunity, and I will give the balance of my time to my client. Thank you.
Thank you, Doug. Hello, distinguished board members. Again, I want to thank you for this opportunity today to allow me to speak on my behalf. First and foremost, I would like to say that I take full responsibility for my part in the event that transpired 9 years ago. It occurred on the last day of my finals of my sophomore year of undergrad after a night of celebrating with some friends. I'd already decided to change to a new school that was better suited for my medical career. When the matter came up after I've already left campus and the community, with the support of my family, my advisor, and at the time my counsel, I entered an Alford agreement for a misdemeanor of assault. Since this event, I've attempted in every way to be a productive member of the professional community and society at large. I understand the tremendous responsibility that is placed upon me as a physician. I know this because for the last several months, I have lived and experienced the joys and sorrows of dealing with my patients while being a resident. I've been working through an unprecedented time in the medical community in which compassionate care and compassionate communication between patients and their loved ones that were not able to see each other, was at the forefront of patient care. This feeling of fulfillment, these joys and sorrows, are ones that only members of the medical community could ever really understand. Now, I know that
I apologize for interrupting. This is the board parliamentarian. The 5 minutes has expired, so I would ask you to please conclude your thoughts.
All right, thank you. I was just wanted to say that my lifelong goal of becoming a physician and living with these joys and sorrows is in jeopardy, and I understand that. And I'm asking for the opportunity from this board to continue my education with my advisors, with my attendings, and to continue growing as a physician and as a person. Thank you.
Thank you, sir. Does the Assistant Attorney General wish to respond?
Good morning, members of the board. I would just be very brief in my response. I don't recall if this was something that occurred at the hearing, but I think that this might have been the first time I heard the respondent accept full responsibility for the matter in this case. The underlying case, which was not litigated at our hearing, which is the proper thing to have done, it was an Alford plea. So we didn't get into the facts and relitigate the underlying. I think the hearing examiner in this case has done a good job of setting forth the facts and circumstances. And I think that given what we've discussed in the hearing and what Mr. Porter put forth, I believe that the recommended sanction is appropriate. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Gianfrante? Do I have a motion?
I move the motion.
Dr. Reddy, do I have a second? Dr. Schoenstein, thank you. I will now entertain discussion concerning the matter of Dr. Gianfrante. Is there any discussion? Dr. Schoenstein.
Thank you so much. So, as we heard, the doctor entered an Alford plea. So that's where a defendant simultaneously maintains innocence but pleads guilty. And this is not the first Alford plea that's come before the board. I'm respectful of its use in criminal proceedings, but my concern is that an Alford plea dilutes the judicial finding of guilt and makes the guilty finding less accurate for the sake of judicial expediency. There's less clarity regarding the outcome when an Alford plea is adopted. But notwithstanding the Alford plea, we have a rule, 4731-1324, which is cited in the R&R. And essentially, our rule provides that plea of guilty to or finding of guilt regarding a crime is evidence of commission of all aspects of that crime. So in that regard, our rule obviates the Alford plea. And so we are right to essentially treat the matter as though there was a clear guilty plea. So this is a case of mitigation. And as we heard, it's not an occasion that is unlikely to recur. I do think he's made full and free disclosure to the board. And I do think he has substantially taken responsibility for his participation in the event that led to his conviction. That said, there are aggravating features as well. We may surmise that there was an adverse impact of his misconduct on the victim and that the victim was vulnerable to that misconduct. So I respectfully disagree that the degree of mitigation is sufficient to justify a lesser consequence than a suspension. I do take defense counsel's point regarding the availability of the ethics courses, especially during the pandemic. There is the possibility that it could be several months before an ethics course is available to the doctor. And if the ethics course is a condition for reinstatement, it could substantially lengthen his suspension. I'm also agreeable to changing the suspension to a 90-day definite suspension and having it commence on July 1st. I think those changes are reasonable in order to avoid unnecessary disruption to the doctor's education and to the residency program. So I would move to amend the order to make the ethics course a requirement to fulfill during the probationary period. And I would further amend the order to a 90-day definite suspension to commence July 1st, 2021. Thank you.
Thank you. Is there any further discussion?
I'm sorry, is there a second to Dr. Schottenstein's motion to amend?
Yeah, is there a second to Dr. Schottenstein's motion?
I'll second.
Discussion.
Okay.
Can you hear me?
Yes. Yes, Dr.
Okay, sorry.
Feigl.
So I agree with most of what Dr. Schottenstein said. I do feel that that there should be a boundary course, again, as part of his courses he needs to take, because certainly this could become a boundary issue for him as a practitioner if his behavior recurs, obviously. The other thing I think is super important is a 5-year probation for this. He's in a training program. I would want to keep him on probation through the start of his practice. And I think extending the probation to 5 years would be warranted personally, so to protect the public. So I don't know if Dr. Schottenstein is willing to amend his amendment to that or not.
So I would be agreeable if nobody objects to amending my proposed amendment to include the boundaries course. I'm not sure how I feel about a 5-year probation regarding this matter, something that has occurred, so many years ago, and where we don't really have any evidence in the, in the subsequent period of time of concerns, and when we've had such good feedback from the professionals who are working with him. So I would be glad to include the boundaries course in my amendment, but probably will leave the probationary period as is for my amendment, if that's okay. Thank you.
Ms. Montgomery?
Actually, but before we continue, I need to ask, does any board member object to adding the provision for the boundaries course to the motion to amend? And seeing no objections, we can consider that to be now part of the motion. Thank you very much.
Thank you, Benton. Ms. Montgomery?
I know I risked my reputation being tough on crime, but I always have had a problem with where 9 years later, it happened when he was an undergraduate. We don't know what happened. Unfortunately, we don't know the effect on the victim. We don't know whether we have an assault or we don't, a physical assault, a sexual assault, if it's a he said, she said after a drinking incident. We don't know any of that. But it's 9 years later. He has a good record since then, subsequently. If this had been 2 years after this happened, I would agree wholeheartedly with the recommendation. But it's 9 years later. He is an adult now in a way that as an undergraduate, we can all agree at the end of your sophomore year, perhaps he was less mature. I'm not at all undermining whatever happened. We don't know. But I just worry about, when we suspend somebody, I'd like to be closer to the event wherever possible. And I think we look excessive when we go 9 years later with no events subsequent. I would rather say we're going to reprimand you. And the other thing I guess I would say to you is that the Alford plea is used oftentimes because, understand now, he's left college, went to another school. He went someplace else physically. He's got this pending. He's got the potential, apparently, of a much larger sentence than he might get should he take an Alford plea. And that's why you do an Alford plea. I don't believe I'm guilty, but I believe they might find me guilty. And I'm afraid that the sentence would be more expensive and much more difficult than if I just say, okay, I'm going to enter an Alford plea. I still didn't do it, but it's because of cost, because of time, because the potential for my getting a far worse sentence is so large. I'm going to take this reduced charge. So I guess I would say, just again, at great risk personally, I guess, because it does sound, it's not great risk, but sounding like a bleeding heart liberal. I think sentences should, I would simply say I would recommend, rather than a 90-day suspension, definite suspension, that the board, at least we talk a little bit about whether this should be a reprimand rather than a suspension. And I would agree with the boundaries course also, and no fine. And to be honest with you, I don't know where probation, other than having the probation last as long as it takes to take the boundaries course, helps this particular individual. And again, we look at probation as not only protecting the public, we also look at, do we want to have just a checklist probation, or do we want to have probation reserved for where we can actually have an impact on the licensee, other than just a piece of paper or pieces of paper which our staff has to follow. So I'd be interested if anybody's interested in it.
I'd love to comment as well. I'm going to vote no on Dr. Schottenstein's thoughtful amendment. And when I do that, similar to the last one, I want to make known that that doesn't mean I'm not tough on crime. That doesn't mean that I don't support the victim or whatever. But looking at the facts of the case, 9 years ago, undergrad, but think about all the other hurdles and vetting he's already been through, right? He had to get into medical school, and he disclosed all this stuff up front. He went to medical school where, they probably had a lot of these courses, because mine did, about, patient boundaries and patient care and all of that. So he went through those educational hurdles. Then he applied to residency, and I'm sure it was no tall order to get a residency spot with a criminal conviction, and he disclosed all of that. And subsequently in the R&R, we see reviews from, course directors, et cetera, that were seemingly positive. I think that we would be doing unnecessary and undue harm for this. And if you just want to punish him, well, he's already been punished by the Court of Criminal Law, and he went through that. So he went through his punishment. So if you want to punish him further, I suppose you could do that if you would like. But I think it might harm his career long term. I actually would support no further action on a case like this. Thank you.
I would too, Dr. Sloan. I would too. I was just trying to find a in between. I would, if you would make that motion, I will second it.
I will not make that motion.
Okay, I will make the motion. I would make a motion to have no further action on this matter.
Benson, I'll turn to you. First vote on the proposed motion by Dr. Schottenstein.
Well, it depends on, we can consider Ms. Montgomery's motion to be a motion to amend Dr. Schottenstein's motion to amend. If that follows, then you'd have to vote on them one at a time. Alternatively, again, we could vote on Dr. Schottenstein's. It depends on Ms. Montgomery. Ms. Montgomery, if you'd like to vote on Dr. Schottenstein's motion first and then go to yours, that would be fine. But you have the right to make this motion that effectively amends the motion that Dr. Schottenstein had made.
Thank you, Ben.
I tell you what, board members, I guess I would make a motion. Let me recast the motion, and I think it should be independent because you've got two very different points of view here, and I don't think it's fair to have Dr. Schott just have them separately up and down. Would be allow that conversation to be clear. I would move if since we haven't had a second on this. I think I can do this because it's not official until the second. I would move that we reprimand Dr. I can't pronounce his name, this doctor, and then move on. No fine, no probation, no boundaries course.
So, then would we have Dr. Schonstein consider adding that to changing his motion to?
As a separate motion, so you can.
Okay. So I thought we would go ahead now and vote on Dr. Schonstein's motion, which is.
I need a second, if you don't mind.
Yeah, yes, there should be a second before we proceed.
Maybe nobody wants to second it.
Do we have a second for Ms. Montgomery's motion?
Ms. Montgomery, if you,
I'll second it.
yeah.
Dr. Pepperell is seconded. Thank you, sir. And we'll go ahead with the vote on Dr. Schonstein's motion.
Actually, just to clarify what's happening here, this is a much more linear. Dr. Schottenstein has made a motion to amend. Ms. Montgomery has made a motion to amend Dr. Schottenstein's motion. So what the board should be voting on now, if there's
Made a separate one. No, I didn't. I just made a separate one. So you've got two proposals in front of you, and I think you can do an up and down on both. I think, Benton, unless as parliamentarian you don't think so. I didn't move to amend Dr. Schottenstein. I a separate.
Correct. Yeah.
well, the motion before the board prior was Dr. Schottenstein's motion, and that's what the discussion was. I would believe, and I would accept input from anyone, but I would believe we would need to consider your motion, a motion to amend, because there should not be two motions to amend the original proposed order before the board simultaneously. Actually, I would invite Kim's input if she thinks that what I'm saying makes sense.
So I think you can't have two motions at the same time.
Yes.
All right, then I would consider it an amendment of Dr. Schottenstein's amended motion.
Okay, so thank you very much. So if there's no further discussion on that, the board would need to vote on Ms. Montgomery's motion, which has been seconded. It was either Mr. Giacalone or
that parliamentarian, correct? I don't mean to question, but how do we?
No, please do.
So anyone can make a motion. I can make a third motion to Ms. Montgomery's motion without people. Don't they have to vote in order? I mean, don't we vote on Dr. Schottenstein's motion first?
The under the standard rules of parliamentary procedure, which the board has adopted. I'm going to mute someone's microphone real briefly to prevent feedback. Thank you very much. Under the standard rules of parliamentary procedure, you can have multiple motions as long as you keep them in order to amend. And as Kim had pointed out, and I had said before, you can't have more than one motion to amend currently before the board. So theoretically, Dr. Fleibel, yes, you could actually make a motion to amend Ms. Montgomery's motion. You end up with a long line that would be my job to keep track of.
No, I understand that, but don't we have to vote on Dr. Schottenstein's motion first before Ms. Montgomery can amend Dr. Schottenstein's motion?
No, if the board had voted on Dr. Schottenstein's motion beforehand, then the original motion would stand amended, assuming it passed. And then if Ms. Montgomery had made a motion at that point, it would be a further motion to amend. But since Ms. Montgomery's motion to amend came prior to any kind of vote on Dr. Schottenstein's motion, it's considered an amendment to what was already before the board. So the board will need to vote on Ms. Montgomery's motion first. And then if it passes, then that is the motion before the board as a motion to amend. If it does not pass, then Dr. Schottenstein's original motion, as modified by him regarding the boundaries course, will stand before the board as a motion to amend.
But if Ms. Montgomery if Ms. Montgomery is willing to withdraw her motion, we could just do them one at a time.
Yeah, that would be the cleanest. Let's just do that.
I'll withdraw it, and then I'll just resubmit it.
Okay.
Does any board member object to withdrawing Ms. Montgomery's motion to amend the motion? And seeing no objections, we can do that. Ms. Montgomery's motion is amended. Of course, Ms. Montgomery has the right, you have the right to make that motion again later if you so wish. And therefore, I'm sorry, Dr.
Since it appears that this is a big issue, obviously. First of all, I want to make it clear before so that this doesn't come across that way too. The previous R&R, I did not mean that the board was endorsing sexual trafficking by voting for that. So if that came across, I super apologize because that was not my point. And similarly, with this, I'm not saying that as well, but I do think it sets a bad precedent for the board to have a case where we have no clue what went on. He pled guilty to a sexual assault. And yes, it was an Alfred plea, but he pled guilty to a sexual assault. And this.
And I'm just going to interrupt. I think the record is assault.
Right.
I'm sorry. Assault. Sorry. Forgive me. Assault of a female, I believe, is how it read. Is that correct? Yes. Assault of a female. And with all of the, with the Strauss investigation, we went back 25 years and looked at people. And the fact that this was 9 years ago, I don't think excuses the behavior. And I feel like we as a board need to say as a board that we don't condone this, whether it was 3 years ago or 9 years ago or 12 years ago. And I think we're allowing this gentleman to have a license to practice medicine. And I still am on the 5-year probation because I think it gets him into practice and allows us to keep tabs on him until he's into practice. But at a very minimum, we need to suspend his license for 90 days and keep him on probation for at least a short period of time. I don't think that's long enough personally. And I know I'm always the one who's pushing for hard sanctions, but I don't think this sends the right message with everything going on in our world and around us to say as a medical board that we're okay with this, even though it was 9 years ago. We have no idea what the mitigating circumstances are, and we're making up circumstances that may or may not be there.
I'd love to respond. So if I vote against Dr. Schottenstein's motion, I am not saying I'm okay with this behavior. And I want to make that very clear. I'm not okay with that behavior. I'm not okay with sexual assault. I'm not okay with hurting people. But I'm also not okay with something that happened 9 years ago, and he's been punished, through the court of law. He was vetted by his medical school, received admission. He received 4 years of educational training on managing patient care. And then he went to residency, and as I mentioned, that's no tall order to disclose a conviction, getting selected, and has received positive reviews. But I want to make it clear that I am not okay with that behavior. I'm not sending that message by not voting for Dr. Schottenstein's motion. Thank you.
So Dr. Schottenstein has made a motion which has been seconded, which we want to vote on. I think we've had a lot of discussion. Dr. Schottenstein, would you be kind enough to restate your motion prior to the vote?
Mr. Giacalone has a question, though, if you'd be so kind.
Yeah, just one comment. It seems like we've got almost an all or nothing situation, and I'm kind of in the middle on this one. And I hate to throw in an option 3 here, but look, it was 9 years ago, and whatever it was, I think there's a big question mark as to what it is. On the other hand, the thing that bothered me, I think, was the hearing officer's question about its veracity, and in particular, he said, quote, "On the other hand, Dr. Gianfrante's assertion that he's incapable of telling lies is simply not credible and probably did more to lower the hearing examiner's effort or comfort level with Dr. Ferrante than raise it." Okay, so that being the case, look, I think 90 days is successful. Okay, I really do. I mean, for 9 years ago, and whatever the case is, I could see slimming that down to 10 days. Okay. For 5 days, okay, just to send a message, probably more than anything. And look, it's not, a no further action. It's not a reprimand. It's still something, But I think it also takes into account, look, it happened 9 years ago. So maybe that's the way to go on this, as opposed to, throwing it out or reprimand or going 90 days, which I think is excessive. So that's kind of my 2 cents on this.
Dr. Shenstein.
I certainly appreciate everybody's points today. I guess I also had that thought of, gosh, it was a long time ago. And I sort of on purpose didn't want to go down that road of saying, well, it happened a long time ago. And so maybe, we'll just let this off. I mean, it is concerning, right? Because what the statute states is that assault is a threat of bodily harm, coupled with the ability to cause that harm, which in turn causes apprehension in the victim. So to be fair, regarding the statute, the way I read it, battery may or may not be associated with the activity, and battery, of course, is where there's actual unlawful physical contact. And again, just to emphasize, there's been no allegation of sexual assault. This is just an assault conviction. And so I guess, we're limited to the 4 corners of the document, right? So I don't want to speculate on what may or may not have happened. I just want to proceed along the lines of saying there has been an Alford plea of guilty to this statute. And so that said, I'm certainly agreeable to, how shall I say, changing my amendment, my proposed amendment, and lowering the suspension. If everybody's comfortable, I would drop it down to 30 days from the 90, if that's comfortable for everybody, if nobody has any objection to that, because I want to be fair and I appreciate all the feedback that, we've had today. So I would just additionally modify my proposed amendment in that regard. And then the other things, because somebody had asked me to restate my proposal, I'd also talked about making the ethics course a requirement to fulfill during the probationary period, and allowing the suspension to commence July 1st, 2021. So it's not like right in the middle of a rotation, which would be disruptive to the doctor's education and the program itself. Thank you.
And I believe there was an addition of a boundaries course.
So that's right. There was. And so that's perfectly fine for sure.
Is it a definite suspension or indefinite, Dr.
I was thinking definite.
So is your amendment now, a proposed amendment, a 30-day definite suspension with a boundaries course to be taken during a probationary period?
Yes, boundaries course, ethics course, and to...
2 courses?
Boundaries and ethics, yes. Unless he can...
Why are we doing boundaries?
Well, because there was a boundary issue. This was an assault on a female. And so I guess that was not my original amendment, but somebody had proposed it and I was agreeable to it. And so the idea being that, again, that the suspension would start on July 1st, I think is where we landed.
So your motion is a 30-day definite suspension, boundaries and ethics course starting during the probationary period for starting July 1.
Yeah, and to move the courses that they may be fulfilled during the probationary period as opposed to being required for reinstatement.
So how long is your probationary period?
Right now, it's at least 1 year. I left that the same.
Sorry, I believe Dr. Reddy has a comment.
Dr. Reddy?
Yes. So I do see the point that, we have to punish, but the punishment should be less than affecting this young physician's career. So I was thinking 30 days is excellent, even before Dr. Schottenstein proposed it. But I was of the opinion that we need to follow him through probation for a little longer. It will not affect his training. And 1 year is, I feel it's okay. The whole idea I have is it happened 9 years, it can happen again, so we have to punish, but the punishment should not affect this young doctor's training program. And at the same time, we prove to the public that we are going to follow him up during the probation.
I'm sorry to interrupt one more time. That Dr. Schottenstein had wanted to change his the motion so that the 90-day suspension becomes a 30-day suspension. I just need to ask if any board member objects to that change in the motion.
I do.
And I see no object. I'm sorry, Dr. Feibel objects to that?
Yeah, I do.
Okay. In that case, the board would have to vote on the motion as it was made before with the 90 days. And then make any further amendments from that point. So right now, the motion stands at a definite suspension of 90 days. This is the motion to amend, that is, with all the other provisions that Dr. Schottenstein had outlined. Thank you.
So now we'll go ahead and take a vote on the 90-day definite suspension as proposed by Dr. Schottenstein and seconded. And we'll want to take a roll call vote on its substance. Dr. Rothermel?
Abstain.
Dr. Saffron?
Abstain.
Mr. Cacalone? Mr. Cacalone?
Sorry, no.
No? Okay. Dr. Swain?
No.
Dr. Schottenstein? You're muted.
No.
Dr. Ratty?
No.
Dr. Johnson?
No.
Dr. Cacarella?
No.
Mr. Ganadakis?
Yes, sir.
Ms. Montgomery?
No.
Dr. Feibel?
Yes.
And Dr. Bechtel, myself, no. Benton, now we turn to Dr. Schottenstein's proposal then for a 30-day suspension.
Well, that was the vote on the amendment, and then the amendment went through some changes, but that was the final vote of the amendment. What's before the board now is the original proposed order that was moved to be approved. The original order in the R&R is now back before the board, and you can accept that or change it as you will.
And to be clear on the proposed order, that was for an indefinite 90-day suspension. Is that correct, Benton?
Yes.
Yes, that is correct. I think Kim's saying so too, but she's muted. Yes, exactly as outlined in the R&R. There's no boundaries course in that, and it's an indefinite 90-day suspension to commence upon the effective date of the order. And also the course that's in there is a condition for reinstatement, not a probationary term.
Okay.
Can that be amended now or not?
Yes, it can be amended.
Okay.
All right. Schottenstein amends it. We can put it back on the table.
So we'll go ahead and vote now on the substance of the proposal. And again, that is a 90-day indefinite suspension.
Unless a board member would like to amend.
Okay. A board member could amend.
Yes.
Rick Schottenstein.
Dr. Reddy?
Oh, sorry. Go ahead.
Dr. Schottenstein?
Oh, sure. So I guess I would just sort of refile my previous amendment, which I had ended up with a 30-day definite suspension to commence on July 1st with ethics and boundaries courses to be finished during the probationary period, which should last at least 1 year. The suspension to start on July 1st, 2021.
I second that.
And I second by Dr. Reddy. Thank you. So I thought we'll go ahead and vote on the substance of the proposed amendment. Dr. Rothermel?
Abstain.
Dr. Saffron? Dr. Saffron? You're muted.
Abstain.
Abstain. Thank you, sir. Mr. Cacalone?
Yes.
Dr. Stein?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Thank you, sir. Mr. Ganadakis?
Yes, sir.
Thank you. Ms. Montgomery?
No.
Thank you. Dr. Feibel?
No.
And myself, Dr. Bechtel, yes.
And the motion to amend passes 8-2 with 2 people abstaining. So the order stands amended for the board to either discuss or perhaps vote on.
Any further discussion? Ms. Montgomery?
Well, I think this is kamikaze effort, but I'm going to do it anyway. It is not based upon the fact that it's only 9 years old. I mean, 9 years, the years is important. What is important is that the time that this event happened, whatever it is, was when he was a sophomore in undergraduate. I think we can all agree that a sophomore and undergraduate were in undergraduate versus 9 years later, as having gone through the kind of medical education he has and matured, that we are the horse has been out of the barn and we're closing the door now. And it seems to me that while we have to do something, the sentence needs to be appropriate, particularly based on age, time, place, and circumstances. We don't know the circumstances. So I would propose to amend what we have just passed to be that we reprimand this doctor and that we require him to take a boundaries course, that there is no fine, no probation, or if there is a probation until that boundaries course is concluded. Let me clarify. I would recommend that we reprimand and require him to take a boundaries course within a set period of time that fits within his curriculum as he's a doctor.
Do we need to specify an amount of time for the course to be completed, like a specific
And
time?
you have no probation, is that correct?
No probation.
Do we have a
If it's sweetened, if
do we have a second to Ms. Montgomery's motion?
I would, if Ms. Montgomery would consider probation, I would consider seconding the motion.
I would consider a reprimand with probation to last until the boundaries course is taken and successfully completed.
I'll second that.
Dr. Coccarella, you second that motion, is that? Okay. Ben, then I think we could go ahead and vote on Ms. Montgomery's motion, is that correct?
Unless there's further discussion by the board, yes.
Okay.
And just to clarify the motion, this will amend the order so that it will be only a reprimand and there will be a requirement for a boundaries course and a probation to continue until the completion of the boundaries course. And there was no mention of an ethics course. So I'm assuming the ethics course will not be included in the order. Is that correct, Ms. Montgomery?
That's correct. Although I am informed that a lot of the boundaries courses also include ethics in the boundaries course.
Thank you.
Very good. Okay.
We'll go ahead and vote on Ms. Montgomery's motion. Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
No.
Dr. Spillane,
Yes.
Dr. Schonstein,
No.
Dr. Reddy,
No.
Dr. Johnson,
No.
Dr. Coccarella,
Yes.
Mr. Ganadakis,
No.
Ms. Montgomery,
Yes.
Dr. Feibel,
No.
and Dr. Bechtel, yes.
There you go. That is 6 votes against the amendment, 4 votes in favor of it, and 2 abstentions. The motion to amend does not pass. What is before the board now is the motion as amended by Dr. Schottenstein.
So Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Gianna Fronte? Do I have a motion?
So moved, Dr. Johnson.
Dr. Johnson, a second. Dr. Reddy, thank you. We'll have a roll call. Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
Just to confirm, this is the 30 days. I just want to make sure. We've had so many amendments going back and forth. I want to make sure we're the right one.
I could clarify if that's okay. This is the final vote on the order. It includes a 30-day definite suspension to commence on July the 1st of this year. It requires both ethics and boundaries courses, which will take place during the probationary period. The probationary period will be for a minimum of 1 year. And I believe I covered everything. And I forget anything, Dr. Shaw.
And the courses may be
Clarify, this is the vote on the amendment, right?
Beg pardon?
This is a vote on the amendment.
This is the vote on the final order. The order is already stands amended by Dr. Schottenstein. Ms. Montgomery's motion to amend further did not pass, so we're back to the proposed order as amended. This should be the final vote.
And also
Yes,
that the courses can be fulfilled during the probationary period.
Yes, I had mentioned that. Those are probationary terms and not conditions for reinstatement.
Mm-hmm.
Thank you.
I'll go back and restart the roll call again after the clarification. Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarello,
No.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
No.
and Dr. Bechtel, yes. Thank you, Dr. Gianfrante, and you may exit the video conference now. And if you wish to view the rest of the public meeting, it's being live streamed on the board's YouTube channel. Thank you, sir.
Thank
I'd
you.
like to thank the members of the board for their careful discussion and consideration of this matter.
In the following matters, the board issued notices of opportunity for hearing, and documentation of service was received for each. There were no timely requests for hearings filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for final disposition. These matters are non-disciplinary in nature, and therefore all board members may vote. We'll turn first to the matter of April D. Hall, RCP, and again, all can vote. On February 10th, 2021, the board authorized issuance of a notice of opportunity for hearing to April D. Hall, RCP, informing her that the State Medical Board of Ohio proposed to deny her application for license to practice respiratory care because she had not successfully passed an examination approved by the board. Ms. Hall had not provided documentation that she had completed the required clinical simulation examination, or CSC, portion of the registered respiratory therapist, or RRT, examination. Do I hear a motion to find that the facts set forth in the February 10th, 2021 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and the board enter an order effective immediately upon mailing denying Ms. Hall's application for a license to practice respiratory care in the state of Ohio? Do I have a motion?
So moved.
Dr. Safran, a second. Dr. Reddy, is there any further discussion regarding the motion? Seeing none, we'll proceed with a roll call. Dr. Rothermill,
Yes.
Dr. Safran,
Yes.
Mr. Cacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Thank you. Dr. Feibel?
Yes.
And Dr. Bechtel, yes. We'll now turn to the matter of Darnica M. Butler. On February 10th, 2021, the board authorized issuance of a notice of opportunity for hearing to Darnica M. Butler, informing her that the State Medical Board of Ohio proposed to deny her application for restoration of her license to practice respiratory care in the state of Ohio because pursuant to Rule 4761-501B of the Ohio Administrative Code, restoration applicants who obtain licensure based solely on the completion of the Certified Respiratory Therapist or CRT examination may only continue to practice under the license so long as they continue to timely renew. Otherwise, the applicants must apply for a new license and demonstrate that they have successfully completed both portions of the Registered Respiratory Therapist or RRT examination. Do I hear a motion to find that the facts set forth in the February 10th, 2021 Notice of Opportunity for a Hearing have been proven to be true by preponderance of evidence, and that the board enter an order effective immediately upon mailing denying Ms. Butler's application for restoration of her license to practice respiratory care in the state of Ohio? Do I have a motion?
So moved. Second.
Second. Dr. Johnson. Is there any discussion? Hearing none, we'll go ahead and take a roll call. Dr. Rothermel.
I'm sorry, Dr. Bechtel. I believe Mr. Giacalone might have a comment. Yes, Mr. Giacalone.
Yeah, just will we tell the respondent about taking the exam so that he is aware and how much time between failure to renew license? And also the other question is, how much time is there between failure to renew a license and the fact that you have to retake the exam? I guess I was a little unclear on that.
Dr. Safran and Dr. Rothermel, do you want to speak to that?
Well, you have to have practiced within 2 years in order not to have to take an exam. So if you haven't practiced within 2 years,
then you have
to take the exam to qualify for licensure.
Okay, great. And we'll tell him that.
I think he already knows.
He's been told.
Yeah, they sent the notice.
Okay, as long as he's been, that's fine.
Yes.
Thank you. Go ahead and proceed with the roll call. Dr. Rothermel.
Yes.
Dr. Safran.
Yes.
Mr. Giacalone.
Yes.
Dr. Swain.
Yes.
Dr. Schonstein.
Yes.
Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Dr. Coccarella.
Yes.
Mr. Donadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
And myself, Dr. Bechtel, yes. We'll now turn the matter of Donghong Bella Dolid. On February 10th, 2021, the board authorized issuance of a notice of opportunity for a hearing to Donghong Bella Dolid, informing her that the State Medical Board of Ohio proposed to deny her application for a certificate to practice massage therapy because she did not hold a diploma or certificate from the school, college, or institution in another state or jurisdiction that meets the board's required course of instruction, and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the February 10th, 2021 Notice of Opportunity for a Hearing have been proven to be true by preponderance of the evidence, and the board enter an order effective immediately upon mailing denying Ms. Bella Dolid's application for a license to practice massage therapy in the state of Ohio? Do I have a motion?
So moved.
Dr. Safran, do I have a second?
Dr.
Dr. Cockrell, thank you. Any discussion? Ms. Montgomery.
Yes, thank you, Doctor. I was wondering if the applicant has been told that just you would be eligible in September of 21 because at that point you would meet the 5-year rule. Am I accurate in that? Somebody can tell me if I'm inaccurate.
Dr. Safran or Dr. Rothermel, would you like to comment to that?
Licensure does communicate quite a lot with these applicants before this decision is made to let them know all of the options that are available. So they would have been told that the 5-year mark makes a difference if they have a license in another state.
Yeah, because that would be important. You would, particularly for these folks who are not making a lot of money as a massage therapist, to let them know, look, hang in there and you could reapply under the 5-year rule. Thank you very much.
They've been offered the ability to withdraw the application as well.
Thank you.
Thank you very much. So we'll go ahead and proceed with a roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein.
Yes.
Thank you. Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Thank you. Dr. Coccarella.
Yes.
Mr. Ganadakis.
Yes.
Thank you. Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Thank you. And myself, Dr. Bechtel, yes. We'll now turn to the matter of Carnetta D. Williams, MT. On February 10th, 2021, the board authorized issuance of a notice of opportunity for hearing of Carnetta D. Williams, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she take and pass a massage and bodywork licensing examination, the MBLEX, due to the fact that Ms. Williams has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the February 10th, 2021 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Ms. Williams' application for restoration of her license to practice massage therapy, provided that she takes and passes the MBLEX within 6 months of the date of mailing of the notice of opportunity for a hearing? Do I have a motion?
So moved.
Dr. Safran and Dr. Coccarella, is there any discussion? Seeing no discussion, we'll go with our roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Capelloni.
Yes.
Thank you. Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Thank you. Dr. Coccarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
and myself, Dr. Bechtel, yes. We'll now turn the matter of Israelite Jasma. On October 14th, 2020, the board authorized issuance of a notice of opportunity for a hearing of Israelite Jasma, informing him that the State Medical Board of Ohio proposed to deny his application for a license to practice respiratory care because he had not passed an examination approved under the rules adopted by the board. The board requires RCP applicants to provide documentation that they have successfully completed both portions of the registered respiratory therapist or RRT examination. Mr. Jasma has not provided documentation that he has completed either of the required exams necessary for the RRT certification. Do I hear a motion to find that the facts set forth in the October 4th, 2020 notice of opportunity for a hearing have proven to be true by the preponderance of the evidence, and the board enter an order effective immediately upon mailing, denying Mr. Jasma's application for a license to practice respiratory care in the state of Ohio? Do I have any discussion? Do I have a motion?
So moved.
Dr. Coccarella, in a second. I'm sorry. Do I have a
Second.
Dr. Second? Okay. We'll proceed with the roll call. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Sir Gacaloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel.
Yes.
Yes, thank you. And myself, Dr. Bechtel, yes. We'll now turn to the matter of Meiwa Jen. On February 10th, 2021, the board authorized issuance of a notice of opportunity for a hearing to Meiwa Jen, informing her that the State Medical Board of Ohio proposed to deny her application for a license to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate in good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find the facts set forth in February 10th, 2021 notice of opportunity for a hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing, denying Ms. Jen's application for a license to practice massage therapy in the state of Ohio? Any discussion? Seeing none, do I have a motion?
So moved.
Do I have a second?
The second, Dr. Coccarella.
Dr. Safran and Dr. Coccarella. We'll proceed with a roll call vote. Dr. Rothermill,
Yes.
Dr. Safran,
Yes.
Mr. Gacaloni.
Yes.
Thank you. Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Thank you. Dr. Coccarella.
Yes.
Thank you. Mr. Ganadakis.
Yes.
Thank you. Ms. Montgomery.
Yes.
Thank you. Dr. Feibel.
Yes.
And myself, Dr. Bechtel, yes. We'll now turn to the matter of Nicole M. McCabe, MD, or MT. On July 8th, 2020, the board authorized issuance of a notice of opportunity for hearing to Nicole M. McCabe, MT, informing her the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided she take and pass the massage and bodywork licensure or licensing examination, the NBLEX, due to the fact that Ms. McCabe has not been engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the July 8th, 2020 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. McCabe's application for restoration of her license to practice massage therapy in the state of Ohio, provided that she takes and passes the NBLEX within 12 months of the date of the final date of publication of the notice of opportunity for a hearing. Do I have a motion?
So moved.
Dr. Safran, a second.
Second, Dr. Coccarella.
Dr. Coccarella, thank you. Is there any discussion? We'll now go ahead and proceed with roll call. Dr. Rothermill.
I have one point of discussion, I'm sorry, but is there a limit? Is it that she has to take the exam within 6 months?
Because it says here in the order, it says within 12 months.
Right, it looks like 12 months.
That's correct, yeah.
And I think that's based on the notice. When the notice was sent, it said 12 months.
Okay. So my vote is yes.
I'm sorry, I believe Dr. Schottenstein has a comment.
Sorry, I was just going to say, I noticed that too, that sometimes it says 12 months, sometimes it says 6 months. And I think that the 12 months has been used more when citations were issued during the pandemic. And there was a feeling of wanting to give people a longer period of time to fulfill their requirement. But it's traditionally been more standard to do 6 months.
Yeah.
Thank you for that clarification. Start again with the roll call. Dr. Rothermill.
Yes.
Dr. Safran.
Yes.
Mr. Gacaloni. Dr. Stein?
Yes.
Dr. Scheinstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Thank you. Mr. Ganadakis?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And Dr. Bechtel, myself, yes. Now turn to the matter of Wendy N. Cunningham, RCP. On February 10th, 2021, the board authorized issuance of a notice of opportunity for a hearing to Wendy N. Cunningham, RCP, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice as a respiratory care professional, provided that she take and pass the clinical simulation examination, or CSE, due to the fact that Ms. Cunningham has not engaged in the active practice of respiratory care therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the February 10th, 2021 notice of opportunity for a hearing have proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Cunningham's application for restoration of her license to practice respiratory care in the state of Ohio, provided that she takes and passes the CSE within 6 months of the date of the mailing of this notice of opportunity for a hearing. Do I have a motion?
Dr. Cockrell.
Dr. Cockrell and Dr. Safran seconded. Is there any discussion? I'll have a roll call next. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Thank you. Mr. Coccoloni?
Yes.
Dr. Swing?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Caparella?
Yes.
Thank you. Mr. Ganadakis?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Myself, Dr. Bechtel, yes. I'll now entertain that we entertain a motion to go into executive session, and following the executive session, the board will take a 20-minute recess before resuming business. Do I hear a motion to go into executive session to confer with the medical board's attorneys on matters of pending or imminent court action, and for the purpose of deliberating on proposed consent agreements and exercise the medical board's quasi-judicial capacity to consider employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official? Do I have a motion?
So moved.
Dr. Safran, and seconded by Dr. Reddy. Roll call, Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Coccoloni?
Yes.
Dr. Swain?
Yes.
Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Ganadakis?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. We'll need to log off of this stream and then log on
This
to the
conference is no longer being recorded.
Sorry.
20 minutes, right?
I know the executive session will start immediately, and the
After-
recess will occur after the executive session.
Thank you.
Thanks.